College and this evening's broadcast of the North Idaho College Public Forum. The crew is comprised of North Idaho College television students. Your moderator is North Idaho College political scientist Tony Stewart.
Good evening, ladies and gentlemen. As you have known from previous shows that we have done, the North Idaho College Public Forum, in cooperation with the Association for the Humanities in Idaho and the Kootenai County Council on Alcoholism, has been bringing and will continue to bring to you over a 12-month period 12 30-minute programs on a very important subject, and that is alcoholism. We're breaking these and bringing 2 programs to you about every 2 months. Back in April, we brought 2 programs to you concerning alcoholism and the field of industry and business. In Part 3 this week and Part 4 next week, we're going to discuss with you alcoholism and the law. In order to accomplish that, we wish to break our discussion into 2 major subheadings. First of all is the general philosophical questions concerning the law and how it relates to the question of alcoholic beverages. The second part that we will discuss somewhat this week and continue next week is on the practical application of the law in relation to alcoholism. In order to accomplish these goals, it is my pleasure to welcome to our program Mr. Bob Speck, who has been involved with this grant and the question of alcoholism. He has a law degree from Gonzaga University here in Spokane, and then he spent 22 years working as an agent with the FBI, and at the present time serves as the Assistant Kootenai County Prosecuting Attorney. Mr. Speck, welcome to our program.
Thank you very much, Tony.
As is true of all of these programs on alcoholism, I'm happy to welcome back our panel that we were using in those subjects. First of all is Mr. Jim McLeod, who holds a BA degree from the University of Washington in Seattle and an MA degree from Eastern Washington State University. He teaches in the field of English and literature at North Idaho College and is a poet. He also serves as a member of the Board of Directors of the Kootenai County Council on Alcoholism. Welcome, Jim.
Thank you, Tony.
Also I'd like to welcome back Judy Silty, who holds a baccalaureate degree from Whitworth College and a master's from the University of California at Los Angeles. She too teaches in the field of English at North Idaho College and is a board member of the Kootenai County Council on Alcoholism. Welcome, Judy.
Thank you.
And our third panel member is Tim Christie, holding a baccalaureate degree from Eastern Montana College and an MA from the University of Montana, Missoula. He is the debate coach at North Idaho College and is also involved throughout this project on alcoholism. Welcome, Tim.
Thank you, Tony.
We would like to open up our program this evening, as we did on alcoholism before, by having a few comments from our panel prior to interviewing our guest. We will start with the question of the scope of problems and statistics relating to that from Judy Silty.
Okay. Let me just share with you a few statistics that have to do not just with the specific problem of alcoholism in the law, but the larger problem of alcohol in the law. Over half of those killed in traffic accidents each year have alcohol in their blood at the time of the accident. More than half of all non-highway accidental deaths are alcohol involved. We find that the leading cause of death in Idaho for the age group between 15 and 24 years of age is alcohol-related traffic accidents, and that 61% of all deaths in this age group are caused by mixing drinking and driving. The FBI has calculated that prior to the spread of laws decriminalizing public drunkenness, in other words, drunkenness, was the cause of every 3rd arrest in the United States. Murder is the 12th leading cause of death in the United States, and over half of all homicides are calculated to be alcohol-related in some way. Alcohol is a major factor in police calls involving domestic disputes, which I think almost all police officers would agree are one of their least favorite and most dangerous law enforcement situations. Alcohol is considered a leading contributor to most incidents of child abuse, a problem that has received a good deal of attention in the 5 northern counties of alcohol, one of our major local social problems. It has also been cited as a major cause of marriage dissolutions and other domestic legal problems in Kootenai County. And I guess all of those should go to prove the last statement, that alcoholism and problem drinking constitute a significant drain in terms of both time and money on the law enforcement agencies and the courts and correctional systems of the state of Idaho. So it's certainly a problem deserving of our attention and discussion.
Judy, we do catalog these TV programs in the North Idaho College Library, and in some future time when someone might be doing research concerning those statistics from our show, we should make the point that this was taped on March the 26th, 1979, and you're using those statistics as of that date.
Right.
Let us turn now to Tim Christie on the panel and have him to give us the historical overview and particularly address the question, how has the law dealt with alcohol in the past? Tim?
Thank you, Tony. Well, one of the situations as far as alcohol is concerned is that alcohol in and of itself, as far as some members of the society is concerned, have felt that, or at least some members have felt that the consumption of alcohol was immoral or improper or for various reasons not the right thing to do. And as a consequence, they have or people in groups or individually have spoke out on the concept of the legalization or whether alcohol should be consumed. In the first, as far as the United States is concerned, the first time that alcohol was actually banned in the United States was in the state of Georgia. And the experiment lasted 7 years from the years 1735 to 1742. And at that time, alcohol was completely banned in that state. However, it was found impractical since neighboring states did not also ban the use of alcohol, and the consequences were that the people would go over to the adjoining states, or that there were rum runners moving between the Carolinas into Georgia. And in 1742, they gave up the law. In 1851, the state of Maine prohibited the manufacture, sale, and importation of alcoholic beverages, and which eventually led up to, in 1919, the establishment of the 18th Amendment. Now, this was probably at the time one of the more unpopular amendments, as was indicated by in 1933 when it was repealed by the 21st Amendment. And I might add that the 18th Amendment is the only amendment to the United States Constitution that has ever been repealed via the 21st Amendment. It's interesting that the 21st Amendment left it to the discretion of the particular states as to whether they wanted to keep the state, quote, dry, and it has continued up until 1966, when Mississippi repealed prohibition in their particular state, leaving all states in the United States where it is legal to drink. One interesting concept is that although alcohol, or the consumption of alcohol, has been made legal, a person who has imbibed, so to speak, or used alcohol, drunkenness, whatever the case may be, is considered in many states, or at points in time has been considered unlawful, and persons could be arrested for the use of alcohol, even though alcohol in and of itself is a legal commodity as far as certain particular ages are concerned. Of course, all states say that it is illegal to drink and drive under certain levels of intoxication and those kinds of things. But there are very strict laws, and have been very strict laws, of where people have tried to make a moral judgment upon the others with the sanctity of laws, as far as...
As we move into this question of law, though, we should make it clear, should we not, that although there are 50 states' codes concerning alcohol, that they all vary greatly in the age one can drink and under what conditions, and there's tremendous change from state to state in those laws, our variety.
A good example is between the states of Idaho and Washington. You're talking about the difference between the age of 21 versus the age of 19 in the legal age as far as consumption is concerned.
We also like to turn now to Jim McLeod, who is the third panel member, and he will discuss for a moment with you the current legal situation in Idaho. Jim?
Thank you, Tony. In the spring of 1976, the state legislature passed the Alcoholism, Intoxication, and Treatment Act in Idaho, which in essence decriminalizes alcohol with regard to public drunkenness. I'd like to read to you, to the audience, TV audience, some excerpts from that act, because I think they're quite germane to what we're going to discuss. It is the policy of this state, the state of Idaho, that alcoholics and intoxicated persons may not be subjected to criminal prosecution or incarceration solely because of their consumption of alcoholic beverages, but rather should be afforded treatment in order that they may lead normal lives as productive members of society. Now, this is a major change because before this, public drunkenness and alcoholism very often was seen as a criminal situation rather than as the Act underscores later, a matter of disease in many cases and a disease that needs to be treated. The other dimension of this Act I think that's important to underscore is the responsibility of law enforcement agencies in dealing with people who are drunk in public places. This is the section under protective custody. In this section, it states, an intoxicated person may come voluntarily to an approved public treatment facility for emergency treatment. A person who appears to be intoxicated in a public place and to be in need of help, if he consents to the proffered help, may be assisted to his home and an approved public treatment facility or an approved private treatment facility or a health facility by a law enforcement officer. What in essence that means is that a person who desires help under those conditions can be taken care of. But more importantly, if the person is incapacitated to the point where he cannot readily indicate whether he is willing to be taken to one of these centers, he can be taken into protective custody by a law enforcement officer and be taken directly to an approved treatment facility, or if no facility is available, he may be taken to jail but not kept there longer than 24 hours. And then hopefully transported to a facility at that point. Now the problem, of course, in Idaho is that not every area in Idaho, not every small town and community has a facility. And so many of these people must come to larger areas such as Coeur d'Alene, and the facility there is the Kootenai County Council on Alcoholism Treatment, well, it's called the Awareness Center in Coeur d'Alene. And I think, as I said, this law is important to our discussion because it shows a major change, at least in the state legislature, attitude towards alcohol and alcoholism, treating it more as a disease now and less as a sign of criminality.
And certainly this is not unique to Idaho. This is a trend across the country in revision of state laws, is it not?
Right, that's correct.
Ladies and gentlemen, we'd now like to have the opportunity to question our guest, Mr. Bob Speck, and we will start that questioning with panel member Judy Sildy.
All right, Bob, I will start with probably the broadest conceivable philosophical question. Is there any sort of underlying principle or value that guides our lawmaking and our law administering with respect to the use of alcohol? And if so, what is it? Some possibilities that have been discussed over the ages. Utilitarianism, for one, the old philosophy of the greatest good for the greatest number of people, which has fallen in and out of fashion over the years, a sort of majority rule, you might say. Libertarianism, the concept of minimal possible interference with personal freedom and rights. The idea of paternalism, protecting the young, the innocent, the less able from things they're not able to protect themselves from. The good basic concept of justice, whatever that may mean. Equality before the law, equal treatment for all. Perhaps even more basic value of human compassion. Do all persons involved with the law, or that probably answers it right there, do most persons involved with the law, lawmakers, attorneys, law enforcement personnel, the judicial, and the general public, see law the same way, see the purpose of law the same way with respect to alcohol consumption?
Well, I think, Judy, to answer, first of all, the first part of your question, is there an underlying principle that guides our lawmakers? I should certainly hope so. But I would think that all of the various concepts that you mentioned may very well come into play as far as our legislators, our lawmakers are concerned. And I think as a practical application, when we talk about making law, passing law, as a practical application, it'd be very hard to determine exactly what allows this piece of legislation or that piece of legislation to get passed, because a particular legislator may be possessed of a particular philosophy. Yet we know from the practical standpoint of getting laws passed that many times he's trading up there. You give me a vote and I'll give you a vote type thing. So we find that maybe a law is passed, becomes legislation, or I mean becomes law, because of a collection of different types of philosophical concepts. I think it'd be very difficult, especially with respect to our laws relating to drinking, or those that cover the subject matter of alcohol at all in any respect. It'd be very difficult to look into them and say what motivates it. What is the lawmaker's motivation for giving us this law?
Panelist Tim Christie.
Okay. Kind of a spin-off, Bob, in respect to what Judy said. John Stuart Mill once said that the only purpose for which power can rightfully be exercised over any member of civilized community against his will is to prevent harm to others. His own good, either physical or moral, is not sufficient warrant. He cannot rightfully be compelled because in the opinion of others it would be wise or even right. Now, in terms of that, what do you see as being the attitude as far as most people in the criminal justice profession, as far as they're seeing their legitimate role in interfering with human behavior? What is their role in terms of, as opposed to making it for the right, protecting other people versus protecting my individual rights?
Well, I believe to a big extent anyway, the person who is charged with enforcing the criminal law, that is your policeman, he pretty well has it laid out for him. The law is there, and the legislator has passed the law is there, and it's up to him to see that this particular thing is enforced. So what calls him into action, so to speak, is not a consideration of Mill's concept at all, but the fact that he realizes a law has been violated. And I don't believe really that he makes any philosophical contemplation in that regard. I think if I've understood your question properly, he's dedicated to the enforcement of the law. And not always would he understand necessarily or attempt to understand the basis for that particular law, the why of it. I'm sure in most cases, however, he realizes. And there again, if I understand you correctly, you were more or less concerned in your question with the enforcement, is that correct, of
That's
the law?
Right. Yeah.
I believe that if the law that the policeman at that time is dealing with has in fact been violated, that irrespective of Mill's belief that we have given the officer the power to go ahead and make the arrest.
Okay.
Or whatever action the law calls for, it isn't always arrest.
Panelist Jim McLeod.
Okay, Tony. Bob, this is a sort of chicken and egg question I'd like to ask you. Does law reflect a culture's values and folkways, or does it shape them? And in that context, I want to read you just a short quote by Carl Llewellyn, a famous legal philosopher. "There is law with an apparent policy of discouraging indulgence in alcohol, and the bulk of us abstain or do not abstain from alcohol and theft for the same reason that we abstain or do not abstain from double negatives. The ways of our environment indicate the course of our conduct." I guess if I can help frame that in a little further, I'm needing to know whether you think that the public attitudes are the ones that primarily dictate what law will be, or do public officials determine largely what it ought to be and then try to educate the public to that situation?
Well, Jim, of course you realize that each one of these questions we could probably write a book on. But briefly, it's my feeling that in a democracy, the people have to dictate, and how they do this, I don't know, there's several ways, but the people have to dictate actually what the law is going to be. And once they have made this this apparent to the legislature, and the legislature has gone along with them and passed a law that reflects a consensus by the people, well then of course I think it does shape them, because as this consensus is manifested then in a law, in other words, the society through the law speaks out and says this is how we feel. As that goes along year after year, the law becomes more firmly bedded, so does that particular concept or the consensus of the people in relation thereto, so that it deepens, and in that way probably does have some effect on shaping the public, the generations coming up dealing with that particular law. But initially, I would hope in a democracy that it's the people who indicate what the law is to be, and that the legislators follow that indication. And maybe that's been part of our problem some of the time. They don't listen too well, or we don't get it out to as a society.
May I interject one quick point here, and that is that polls have been taken quite often after a legislature adjourns, and 80 or 90% of the people cannot tell you what laws did pass. How do we get over that problem?
Thanks a lot. No, this is true, and of course, this is one of the reasons why we have political parties. They represent a philosophy, and that philosophy then has inculcated with it then particular principles that they're supposed to follow, supposedly, either party. So in that way, by electing that particular person, theoretically, if not actually, then we give him license, so to speak, to enact a platform or a philosophy, for want of a better word. Then in other respects, I think the legislature has to look at the way things are going in society and say, because of this and because of this and because of this factor, this is the way people feel. And that's an awful responsibility, because he's supposed to be accurate in that regard. Judy Sylvie.
Okay. I seem to be the statistic lady here tonight, but I have another interesting study that I'd like to read you a couple quotes about and then ask you a question about. We all do a lot of talking about how diverse our American culture is, and I think this is one reflection of it. The results of some studies that have been done on varying cultural attitudes toward alcohol. It has been observed that Baptists, Christian Scientists, Methodists, and Mormons do not accept drinking at all in accordance with their code of total abstinence. That Orthodox Jews, on the other hand, both accept and practice drinking on religious grounds and in moderation at the same time that they disapprove of intoxication. That Italian Americans accept drinking in moderate to fairly large quantities on social or convivial grounds at the same time that they disapprove intoxication and completely denounce alcoholism. That white American non-ascetic middle class of Protestants, I suppose that's just a typical academic way of saying a WASP, permits drinking on convivial grounds and permits intoxication at the same time that this group disapproves of alcoholism. That Irish Americans accept and encourage drinking on utilitarian grounds. They permit intoxication but rule out alcoholism. And finally, that Black Americans accept and practice drinking on convivial grounds, that they permit intoxication, and that they tolerate alcoholism. I guess that could all be summed up by saying no two of us agree entirely on our values, nor do any two subcultures agree very much about our alcoholic practices. How is that kind of cultural diversity and ambivalence, if you will, about drinking reflected in the law? What kinds of inconsistencies and dilemmas do we see?
Well, I do believe that there are some, and whether or not they're attributable to religious, racial, or other types of inconsistencies, I do not know. But I know there are some of us who do not need a reason to drink or grounds upon which to drink. But to try to answer your question, I think that possibly the laws vary between Idaho, say, or northern Idaho and Utah, and other states too, California and Washington. And the reason for that variation, or those variations, probably would be religious or ethnic backgrounds. The Irish have a good reputation for liking a bit now and then. And I do believe, however, the inconsistencies aren't all that important to the law, because there are other inconsistencies too with respect to the religions and so forth that we get along with. In other words, these people who are absolute teetotalers, they tolerate very well us folks who are not. So I don't see any big problems. However, there are inconsistencies. You can get arrested in one state for being blowing up the balloon, say at .08, in Washington, I think it's .10 or .10. So there are consistencies. What causes the inconsistencies? Why the people aren't, or why the laws are not uniform all over, I really couldn't say.
Tim Christie.
Okay. Bob, one of the things that I think is somewhat disturbing for some people is the attitude that I guess some people would call it a prohibitionary mentality, that if it is not within congruence with my own moral values, that we should legislate against it, and for the idea that this kind of legislation can create problems. What are your views with respect to that, and what kind of implications does that have on law?
Well, I think that relates back to the chicken and egg question of Jim's, too. Where does our law emanate from? And there again we have the practical aspects and then the theoretical aspects of where our law begins. I'm not sure I'm in agreement with this concept of being an old tradition that if we don't like something, we ought to legislate against it. I personally feel that there's some tendency on the part of the new generation, we might say, or the present generation, to, if we like to do something, let's make it legal.
I must interrupt at that point. We're out of time. Ladies and gentlemen, our program this evening has been dealing with alcoholism in the law. We're going to come to you again next week with the same subject, and we're going to deal with application. However, in the meantime, although this may be more appropriate next week, if some of you are interested in contacting the center in your community concerning this very important issue, you can do so. In Spokane, it is the Spokane Alcoholic Rehabilitation Center at West 1513 8th, or telephone 624-3251. For those viewers in northern Idaho, in the Coeur d'Alene area in particular, you can call the KCCA at it's at 810 River Avenue, or the telephone number is 667-9571. Please be with us again next week, and we will continue this important discussion in Part 4. I am Tony Stewart. Have a good week.
The North Idaho College Public Forum can be seen at this same time each week over this station. This production was videotaped earlier by a North Idaho College student crew for viewing at this more appropriate time. Welcome to the campus of North Idaho College and this evening's broadcast of the North Idaho College Public Forum. The crew is comprised of North Idaho College television students. Your moderator is North Idaho College political scientist Tony Stewart.
Good evening. We've been bringing you over the past few weeks at certain intervals an issue that's very important, we believe, to our society, and that is the question of alcoholic beverages, their consumption, and alcoholism. Last week, we brought you part 3 of this series. It's going over a 12-month period. Tonight, we're going to bring you part 4 of that series. And as far as our present guest is concerned, it will be program 2 with him. Our guest is Mr. Bob Speck. He holds a law degree from Gonzaga University and has had 22 years experience with the FBI and presently serves as the Assistant Kootenai County Prosecuting Attorney. Mr. Speck is with us to continue our discussion of how the law affects the whole question of consumption of alcohol and alcoholism. We're doing these programs in cooperation with the Association for the Humanities in Idaho and the Kootenai County Council on Alcoholism. To join with me in questioning our guests this evening, I'm happy to welcome back the 3 panel members that are involved with this grant. First of all is Mr. Jim McLeod, holding degrees from the University of Washington and Eastern Washington State University. He is in the English department at North Idaho College and is a poet. He also serves on the board of directors of the Kootenai County Council on Alcoholism. Welcome back, Jim.
Thank you, Tony.
Also, I am happy to welcome to our program panelist Judy Silty, holding degrees from Whitworth College and the University of California at Los Angeles. She, too, teaches at North Idaho College in the field of English and literature and serves on the board of directors of the Kootenai County Council on Alcoholism. Welcome back, Judy.
Thank you.
And I'm also happy to welcome to the program once again panelist Tim Christie, holding degrees from Eastern Montana College and the University of Montana, Missoula, is the debate coach at North Idaho College and is also closely associated with the grant from the Association for the Humanities in Idaho on Alcoholism. Welcome, Tim.
Thank you, Tony.
We'll start the questioning this evening with Jim McLeod.
Thank you, Tony. Bob, a real dilemma occurs, not just in laws, but for the individual making ethical and moral choices, between when we must choose 2 goods which appear antithetical. Good examples of conflict between, say, compassion for the drinker with concern for his innocent victims. What kind of confusion does this dilemma present to the lawmaker and the law enforcer? What I'd like you to do, I think, is relate that to your own experience, as to anything that you can think of that where you've had some personal knowledge of a specific case.
Well, Jim, I think that truly there is a dilemma, not just for the lawmakers and the law enforcement people, but for everyone. When we're dealing with laws relating to alcohol, for instance, the driving under the influence law, we're not dealing necessarily with people who have a medical problem from the standpoint that they're alcoholics, that they have serious drinking problems. There are people who are arrested for DUI that maybe once or twice throughout the year they get into a situation where they have consumed enough alcohol to where they would blow up the balloon to establish by law the presumption of intoxication. Some of these people are very good citizens, cause no problems whatsoever, live in the community, support the community, pay their taxes, cause no problems with the law enforcement people whatsoever. And on this one occasion, they're picked up. In Idaho, for instance, they're arrested and they're taken to jail. And this has to be a tremendously humiliating experience for an individual who is considered to be a law-abiding citizen. And then on the opposite side of the coin, you have the person who continually drinks to excess, continually tries to drive an automobile, and sooner or later he runs over somebody and kills them. And you've got to have compassion. You've got to have feeling for that particular person who, through no fault of his own, lost his life because someone habitually violating the law did it once too often. So every one of these situations does not point up the same picture of a law violation or of a criminal. We have the law being violated by people who are not necessarily criminals, and those who are violating the law trying to be criminals. Judy Silty.
Yes, we talked last week, Bob, about the old, what we're calling the chicken and the egg controversy, about whether law reflects or actually shapes social behavior, in this case related to the debate over the legal drinking age. I've read a number of articles just in the last 3 or 4 months about Massachusetts. I know the states all begin with M. Massachusetts, Minnesota, Montana, I believe, have all either considered or enacted laws raising the legal drinking age again from the lower ages that were enacted about 10 years ago, citing statistics and just logic, leading them to believe that lower drinking age has encouraged more teenage drinking, greater numbers of teenage deaths from mixing drinking and driving, so on and so forth. I wonder how you feel about that. Will raising the legal drinking age in Idaho, or anywhere else for that matter, keep younger people from drinking, or is it your opinion that they'll pretty much be guided by the group no matter what the law is? And would you, as prosecuting attorney, favor a raising of the drinking age?
Well, to be consistent, Judy, I would favor the law establishing a drinking age that would be, say, the most effective in dealing with the whole problem of alcoholism, or the drinking problem, as we like to call it. And I can't say what that age would be. It's my own feeling that we were wrong when we lowered it. I'd like to see it back at 21. I believe from a standpoint of health, and here again, I'm a layperson relating in a doctor's field, but I think that a teenager is in a developmental stage of his or her life where the harmful effects of alcohol are more pronounced, and that there's a greater possibility of injury. I also feel that the state of intoxication can be greater in a juvenile, a younger person, because of his youth, because of his age, than it would be in an older person. In other words, the tolerance to alcohol is less, I feel, and this I'm saying this from a personal experience. I was around during World War II when 18-year-old people were going into the service and saw a lot of 18-year-old drinking. I think that an 18-year-old and younger does not carry his booze as well as a more mature person. I think that an older person who has had a chance to mature, say 21 and on up, can make a little better decision as to how he wants to do his drinking, and is probably, if has not been drinking up to that time, is probably at a better position to enjoy moderation.
Can I ask just another question? There is a school of thought that goes that half the problem with teenage drinking is precisely because of the fact that it is illegal, that it has been labeled an adult activity, and that if we made teenage drinking no more illegal than teenage coffee consumption or something like that, we would have a lot fewer teenagers out getting loaded just in order to establish their adulthood. In other words, we'd probably have no more drunk teenagers than we would teenagers who go out and really get loaded up on coffee or something like that. It's your opinion that that's not very good reasoning, I take it.
I don't know, really. I think that much of the problems we have, say, in delinquency, demonstrate that teenagers take a delight in doing just the opposite of what the adults are doing or what the adults contemplate should be done. So I really can't say with respect to the drinking whether or not the fact that it is against the law prompts them. It's like the old stolen watermelon tastes better type thing. I don't think I go along with that, but you understand that my position on the age of drinking, I feel, is probably a minority one. I wouldn't doubt if people wanted to lower it even more than what it is today. But I think that eventually experience might teach us that we might have to bring it back up.
I think we have to bring in one more question here because this is a program sponsored by a humanities grant, and a humanistic question might be, I think, in concerning comparing alcoholism with other types of law. Is it humanistic, or at least is it fair, to to ask from a teenager, 19 years old, for example, that he or she is old enough to meet other responsibilities in society. We think they're mature enough to fight for our country, and therefore we, in wartime, draft them, or we allow them to sue or be sued under contracts. Do we run into a problem with this humanistic question when we say that we will not treat them equal in all respects? That in some, when we're talking about one subject, we say you're very mature. Then we move to another subject and say they're not. Does this cause concern? I'm speaking from a philosophical viewpoint with lawmaking.
Yes. It probably does cause concern, Tony. I feel that going to war really has nothing to do with drinking whatsoever, and I don't know why the two have to be equated at all. If you're old enough to go to war, you're old enough to drink. I don't believe that. I'll tell you this, if you're old enough to go to war, you're going to drink whether you're old enough to drink or not. I find that once you get away from home and away from parental supervision and into a situation like the military, you are going to drink, and you're going to do it whether it's legal or not. But most of our time in this world is spent, hopefully, in a non-war situation, and it's very common for the person to be at home and under some sort of parental, if not jurisdiction, at least influence, so that I think that most 18-year-olds that are living at home would not drink because it was against the law, and that their parents would not allow it for that reason, that it was against the law, leaving out the health factors and that sort of thing. I wouldn't be drinking beer or anything else at 18 if I were living at home, because my father wouldn't allow it.
Tim Christie.
Bob, I want to talk about a practical problem that I think law enforcement has to deal with. Oftentimes the general public sees the law enforcement officer as being the person who would, quote, enforces the laws in terms of arresting people, etc. But one of the problems seems to be that there is, to some degree, a state of discretion available to the patrol officer. For example, sometimes one patrol officer may pick up a person who is intoxicated and take him home. On another occasion, another patrol officer may pick up the person and throw him in jail. How much discretionary power does the patrol officer have, and is it within the realm of the patrol officer to make, quote, those judgment calls?
Well, Tim, I think that's a very good question, and it's one that concerns all of us, because I believe that the quality, really, of justice is measured to a good extent by consistency. I think that's a requirement, that we must be consistent in applying our laws to everyone. Now, what I'm about to say now will probably sound like a disclaimer of that. However, I think that the officer has to have a certain amount of discretion, and the reason for that is there are no two cases the same. There are certain factors present in one case that aren't present in another, and you won't find any situation that has a sum total each of the same circumstances. And I would like to think that we have police officers that are capable of making a determination and do have a little bit of heart, or quite a bit of heart, that have compassion, and once in a while are willing to take it upon themselves to take a drunk home. In other words, I don't think we have to issue a ticket every time there's a violation. What we're dealing with in a good bit of this are not criminals. They're people like you and I, and there, but for the grace of God, go I in some of these drinking situations. So when does he do it? When does he exercise the ticket or the compassion? I don't know, but I think we have to have people that are capable of making that. Does that answer it?
Yeah, I probably think that the situation that the general public probably doesn't understand is at what point does the law officer make his judgment absolute as opposed to those of the courts? Because I think sometimes the general public views the law officer, and I know this is not necessarily a good analogy, but I think it is an analogy of, for example, the speed zones. You know, for example, they'll see somebody driving 65 miles an hour, and then, you know, they go down the road and they're going 65 miles an hour and they get picked up. I mean, once they go out and they have a couple beers and they get picked up and they see some drunk on Saturday night and he isn't picked up, you know, at what point is there consistency?
Well, of course, it's hard to say on the speeding situation. Most officers operate on a policy whereby they'll issue tickets to anyone that's over, say, 6 miles over the limit, or 7 miles, or 8 miles. From one part of town to the other, from one office to the other, there may be inconsistency in that, but you've got to realize that all the people, regardless of when the officer acts, all the people were speeding from 1 mile an hour on up. And it's, in a way, it's kind of like, I guess, the biblical story of the workers in the field. You remember, the people that worked the last hour got the same pay as the people who were employed all day long in the vineyard, or whatever field it happened to be. And this seemed unfair, you know. But I think that if the individual is speeding, that regardless at what stage this particular officer caught him at it, he hasn't got too much to complain about inconsistency. As far as drinking, there are certain things you have to have in order to prove a case, and those things have to be present. Now, some people, of course, are out driving while they're under the influence because they're so drunk they couldn't walk, so they got to be driving. If you might take it from that standpoint, then down to the guy that's a borderline. And here I think many times the law officer has and should use some sort of discretion. And a lot of the times that decision is made upon his confrontation with the individual. And many times he'll make his judgment upon whether or not the guy seems to be impressed with the fact that he is violating the law, or whether he's going to give the officer a bad time. So many times the citizen, I think, gets an opportunity to ask for a ticket by his demeanor and by his attitude. Judy Sildy.
Yeah, this seems like a good time to ask the question, shouldn't we be discriminating between the terms drinking and drunkenness and then alcoholism? Does the law make this distinction at all? And what is the law's concern with each term?
You want them all?
Yeah.
No, certainly we should, because the law does. And many times when we talk about alcoholism, we get the feeling that we're talking about alcoholics, the people that drink because they're compelled to. And this isn't true in the law. As we stated before, the social drinker, the person who drinks occasionally to celebrate some sort of incident like a anniversary, wedding anniversary, or birthday, or happens to be at a reception, wedding reception, and with friends that he hasn't seen for a long time, and takes on just a little more than what he usually drinks, probably could not be said to have any drinking problem. But on this one occasion, then, it's very easy for him to get involved. That's a drinker. And I think you could put anybody that drinks to any extent in that first category, the drinker. Then you go on from that to the drunk. And this could, at times, include the drinker. And then it also includes an individual who makes it a steady habit of drinking to excess and is drunk a good bit of the time, or many times, once a week or once a month, but is sincere in his drinking to the point that he continually drinks too much. Then there's the alcoholic, and there are many definitions of an alcoholic. However, I'm talking about a person who has to have booze, not from the standpoint of a psychological, but from the standpoint of a physical craving that he cannot control. The body, the booze is taken over to where he has to have it, much the same as an individual that's hooked on another type of dope, heroin or something like that. It's something that he has to have, and there are such alcoholics. They're frequent. And I think that the law, in many respects, treats them all the same. That once you get a ticket for driving under the influence, we do not discriminate between the alcoholic, the drunk, or the drinker. As long as what is the key in driving under the influence, for instance, is whether or not this person's capabilities were impaired, his judgment or his physical capabilities were impaired to any extent by booze, alcohol.
Correct me if I'm wrong on the statistics, but I believe during your public forum for the public, when this came out, that in defining all these terms of all those people who drink, I believe about 7 out of 8 drinkers do not become alcoholics. So I think that's a good point to get across too, because we might leave the impression that all drinkers are alcoholic in nature, and that's not the case.
No.
Jim McLeod.
Just to follow up on this question of the drinker on the road, Bob, I know that, for instance, in the state of Washington recently, there was a case of a bartender named Donald Lewis who served a man, this was in Port Orchard, Washington, at least 4 drinks, and as a result of this man had a serious auto accident, injured several people, and was killed himself. The bartender, Donald Lewis, was charged then in Kitsap County with aiding and abetting drunken driving and with reckless endangerment for allowing a drunk out on the highway with a vehicle. Now, I've had some personal experience myself with this, and since this is a humanities program, I guess I could interject my own human situation into that to say that last spring, as a matter of fact, about this time, some students of mine took me out to a local establishment. Actually, I drove myself over there, but decided to, as a joke, load my drinks. Now, this is not a common situation, I'm sure. They got the barmaid to go along with this, and as a result of this, I had something. I have a calculator here that's from the state of Colorado, the Highway Department puts out, and I estimate my blood alcohol content as nearly as I can, about 0.20, which is about twice what is legal intoxication in the state of Washington. That's not the only situation of that sort I've encountered. I know on one occasion one of my students was also in that situation, and I took her car keys away from her and gave it to the barmaid, and she gave them back. Now, what I guess I'm curious about is how much responsibility does the bartender in situations of this sort have legally? Mm-hmm. And particularly, I guess I'm talking about Idaho, but I guess this is a problem throughout the country.
Yeah, well, in reference to your Washington, was that a Washington or Oregon case that you were talking about?
That's a Washington case.
Yeah. Well, I think that probably the bartender in most states is governed by the law to a certain extent. In most states, they have laws that provide that a bartender shall not serve someone who is drunk or intoxicated. But these are very difficult of enforcement. Now, this bartender in your cited case that was charged with aiding and abetting a drunken driver, this same charge could have been brought against your fellows, your so-called friends, who helped get you drunk by overloading your drinks. I mean, the facts are the same. But this is a good point that relates to Judy's previous question: where does the law distinguish? In the law that prevents a bartender from selling to a drunk person, it distinguishes, because it makes it legal certainly to serve people who are under the influence, people that have had 2 or 3 drinks. Yet it will not allow the serving to a drunk individual.
Tim Christie.
Okay, Bob, we've talked about a lot of problems and a lot of situations that have come up as far as the law is concerned. I guess this is kind of piling it all on you, but as a person with a great deal of expertise in this area, what do you see as the solution?
Well, Tim, I got to hand it to you. for the type of question you that you asked. That's a terrifically good question, and I do not have expertise in this field at all, and I know very few people that have, except in the drinking aspect. I have a certain ability, but I think it's education, and really when you come right down to it, this is where we reach, you might say, in a lot of our problems dealing with people. But I think that there are examples in foreign countries, countries that are much older than ours, that have been here longer than we have, where they don't seem to have the problem with drunkenness. And they've had liquor, alcoholic beverage around a good bit. As a matter of fact, many times it's in countries where you find the water is poor and people drink with their meals a great deal. Probably drink more alcoholic beverage than they do water. But they handle the problem, and I think then that our answer here in this country is a matter of education, that we have to learn to be moderate, learn to enjoy our drinking, and not to abuse it. And I think that can be done.
With that, I'm going to bring our program to a conclusion. On behalf of our staff, I want to express our appreciation to you, Bob Speck, for being with us on these two programs.
Well, I want to thank you for inviting me here.
And I also want to express my appreciation to the panel. They've worked very hard and will continue to be with us on the other programs on alcoholism. Ladies and gentlemen, now over the past few weeks, we've brought you 4 programs. In about 6 or 7 weeks, we will again bring you 2 more programs on the question of alcoholism in another area. I hope you'll be watching for those. Next week, we will deal with another subject. But let me close this program by once again bringing to your attention the fact that if you live in Spokane or in Coeur d'Alene, there are centers that you could contact if you have any questions concerning alcoholism and its importance to your community. The first one is the Spokane Alcohol Rehabilitation Center. That telephone number is 624-3251. For those in North Idaho and Coeur d'Alene, they can call at 810 River Avenue. The number is 667-9571. I hope you've enjoyed our program and found it helpful and informative to you. And I would like to invite you to be with us again next week. I am Tony Stewart. Have a good week.
The North Idaho College Public Forum can be seen at this same time each week over this station. This production was videotaped earlier by a North Idaho College student crew for viewing at this more appropriate time.